Good afternoon, all. We welcome Prashant Narang, Deputy Program Manager at TrustBridge, to share a critical examination on the paper on Customs Authority on Advanced Ruling, which he has co-authored with Vijay, Chauhan, and Monika, Yadav. I now hand over the session to Prashant.
Thank you, Swani. Hi, everyone. So this paper is about Customs Authority for Advanced Rulings. We did a process audit of this institution, as in how they pass the advanced rulings, do they adhere to the timelines. But before all of that, let me first talk about what are advanced rulings. So advanced rulings are determinations provided by the Customs Department in writing to applicants prior to trade. So before they import anything, they can approach the Customs Department and ask for relevant information. For example, it could be related to tariff classification or customs valuation, could be related to duty calculation or quotas or rules of origin. It's globally recognized as a trade facilitation tool under the WTO Facilitation Agreement. Why does it matter? So advanced rulings provide clear preemptive guidance from custom authorities, and it mitigates risk in the sense that after you import something and it gets stuck at the customs department because you don't agree on valuation, or if the field officers ask for higher valuation, higher duties, then you are stuck. And if you go in for appeal or some legal recourse, that would take longer. And that would cause a lot of trade-related inconvenience. So advanced rulings provide an option to get the information related to valuation in advance. So it could be related to tariff classification, it could be related to rules of origin, etc. Now we look at India. Before 2018, India had an authority for advanced rulings, slide number 4. This authority was a unified authority, both for direct and indirect taxes. It was led by a retired Supreme Court judge. So the authority was highly formal. It was court-like authority. And it faced a lot of challenges. Number one was severe procedural delays. What was supposed to be done within 2 weeks, it was getting done in years. So it would take years to get an advanced ruling. And so that defeated the whole purpose of getting an advanced ruling, because advanced ruling is, you plan to get into trade, you plan to import something. So you need that information in few weeks, right? You can't wait for years. And if it takes years, then nobody would go and file for advanced ruling. It was only in Delhi, so centralized location, creating some accessibility barrier. Of course, the judge was the only member on the bench, and so there was no technical expertise available. And that also, created some operational hindrance. After 2018, this was also one of the reasons was GST. Because of GST, the tax-related advanced ruling authority was then segregated, and for customs, we had a new authority called Customs Authority for Advanced Rulings, CAAR. And this was custom-focused institution with 2 decentralized benches. So one was obviously first in Delhi. Then they also started a new bench in Mumbai. And the major change was that from retired Supreme Court judge, they shifted it to bureaucrats. So public officials who were already board commissioners in the customs officers, they took it over. And they had the domain expertise, and from judicial body, it became a quasi-judicial body. It reduced delays, it simplified the application process, it enhanced decision-making quality, because the presiding officers they had better customized, they had better domain knowledge. How do we know this? So I'll come to that later when I talk about the interviews and what data we collected. Why do we want to evaluate Customs Authority for Advanced Rulings? Because this authority studying this authority aligns with our trade with the trade facilitation goals, this helps in assessing effectiveness, in reducing trade-related uncertainties and disputes. We want to understand if the transformation from R to CAR led to better compliance with the 90 days target timeline. We want to review the uniformity and applicability of rulings nationwide, or at least how stakeholders perceive that. What do they think about this legal provision? And finally, we want to understand if there are any operational challenges, and if there are, then what are the ways to address those operational challenges? So how can we make the body more efficient and more effective? This would help in aligning India's CAAR with international standards and also help in ensuring ease of doing business. Okay. Let's take a look at the legal framework of CAAR. So this was established under Chapter 5B of the Customs Act 1962. The regulations came in 2021, and the Section 28I6 mandates that the ruling would be issued within 90 days from the date of receipt of a completed application. Regarding the binding nature of rulings, so advanced rulings by definition, they don't have a universal precedential value, as in they are not binding on public at large. So they are not binding to all the importers. They are only binding to the applicant who seeks an advanced ruling. This is how advanced ruling operates across the world, that it is only binding to the person who is seeking the advanced ruling. So that's something common across all jurisdictions. Okay. In India, an advanced ruling is valid for 3 years. Now, how the process works in practice, as per the regulation. So in theory, de jure, as per the rules, an applicant can submit form electronically or physically with minimal fee. Now, when we say electronically, I want to mention that they don't have a portal. Electronically would mean that there is an email, so you send it by email. They said that they're going to soon have a portal. Foreign entities can apply through email submissions. CAAR screens application for completedness, and if there are any defects, like it happens in the courts, they should be rectified promptly. The applications, once it is submitted to CAAR, CAAR would forward it to the jurisdictional principal commissioner or commissioner of customs. Now, which port commissioner would they submit it to? So the applicant would specify and would impede the concerned port commissioner. So there may be many ports. There are ports, for example, in Visakhapatnam, Chennai, Bombay, etc. So the applicant would choose where they are going to import their goods, which port, and so they would impede those ports. And why that is relevant is because in India we have port-specific applicability. So the advanced ruling would apply only to those ports that are included. They will not apply to all ports. So the applicant would receive commissioner's comments and have 2 weeks to reply. The commissioners also have 2 weeks to respond. So once the application is submitted, it is sent to the commissioner. The commissioner has 2 weeks. They will send their reply, and then the applicant has 2 weeks if they choose to file a rebuttal to the commissioner. Okay. Then typically, CAAR also has a hearing, and if they don't receive any comments from the commissioner, they can choose to go for ex parte ruling, or it is discretionary. They choose to wait. They can wait for the comments to come. The comments don't come within 2 weeks. They can choose to grant extensions and choose to wait. Okay. The ruling, along with reasoning, has to be provided in writing within 90 days statutory limit. If it is not provided in 90 days statutory limit, nothing happens. Nothing happens to the to the presiding officer or the commissioner for not submitting their comments within 2 weeks timeline. It's only it causes basically inconvenience to the applicant who is an importer or a business entity, but otherwise there is no issues if the timelines are not adhered. If we compare with USA, Canada, and Australia, in India, the applicability to specified ports, but in these countries, an advanced ruling applies to all ports. So it has a nationwide applicability. An Indian advanced ruling is valid for 3 years. For Australia, it is 5 years, and for Canada and USA, it's indefinite validity. When we say indefinite, it means until there is a change in law or circumstances. In India, we have a process wherein we saw that the application is shared with the port commissioners, who then have to comment, and then the applicant also has an opportunity to file a rebuttal. So it's akin to a quasi-judicial hearing. It's akin to an adversarial hearing where both parties have chance to go through each other's submission and then comment on it. But in other jurisdictions, it doesn't happen like that. You file an application and the department, with the help of the researchers, give you a response, will give you a reply, right? So they don't send it to port commissioners for their comments. So they have independent in-house technical expertise. So the difference between Indian model and global model is Indian model limits uniformity and predictability, creating disparity between ports, because one port the port that which you have completed is bound by advanced ruling. So the advanced ruling says that this product belongs to this classification and hence attracts this sort of tariff duty. That port is bound. But the other port which is not bound, and for whatever reason, if you got your imports delivered at that port, then they are free to assess and choose their own classification, right? Which would lead to disparity. Now, our choice of method for this study was mixed method approach. Why we chose mixed methods? Because there were limitations in the quantitative method with respect to the data. A number of advanced rulings were not available on the website. Then we checked Manupatra. So we managed to get some advanced rulings from Manupatra, but not all advanced rulings were available. Some of the advanced rulings were not available because they were confidential. So the law allows the authority and the applicants that if they want their ruling to not be available in public domain, they can request that, and the authority will not then have the ruling in the public domain. But some rulings that were not confidential were generally not available for technical reasons. So we wrote to the authority. So some rulings were updated after some time, and we managed to then get access to more rulings, but we still didn't have access to the full data. And because of which we couldn't further conduct, let's say, regression analysis or more meaningful comparisons temporally, etc. And so we limited ourselves to frequency distribution and descriptive statistics. But we also then complemented this study with qualitative methods. And so we reached out to stakeholders and we conducted interviews. Apart from these two, we also did a bit of comparative and institutional analysis to benchmark CAAR's performance against international practices. The approach we followed was a convergent parallel design that we simultaneously collected both data, quantitative as well as qualitative, and then analyzed those independently and then integrated for comprehensive insights. So first, I will discuss quantitative data collection. As I said, we gathered the advanced rulings from the CBIC website, Central Board of Indirect Taxes and Customs, and also some of the advanced rulings we managed to get from Manupatra, which is a judgment repository. Total rulings that we were able to analyze were 414. 52% were accessible. And when I say that we analyzed 414, but not all of them were available, what I mean is that on the CBIC website, they have a list of the rulings. So for which they have mentioned the date of filing and the date of the ruling. So we were able to at least calculate the timeline of most of these rulings. Some of the rulings, there were still problems because some of the rulings, in some cases, they did not have the precise date. They just had the month. And so we have to presume, and we presume the last date of the month. For some rulings, for a couple of rulings maybe, there was just no date mentioned whatsoever. And so we had to then omit those, skip those, and do our analysis without those ones. 11% were confidential, 21% were inaccessible, and 14% were rejected. So the rejected and withdrawn, we skip those for a couple of other data points. So what we were looking for, one is compliance with statutory 90-day timeline limit. Second is distribution of ruling subjects, classification or valuation origin notifications. What are people asking for? What are applicants asking for? Are they making inquiries related to classification, or do they seek rulings with respect to valuation or origin, etc.? We looked at concordance rate. So when an applicant files an application, they also submit what they think is the right position in law. And in how many rulings does CAAR agree with the applicant? And that would show the certainty in law. And so that's also one question of interest for us. And finally, workload distribution, because there has been a demand for an additional bench of CAAR. And so we wanted to kind of make an assessment if really there is an additional bench needed. So as I mentioned, that we did descriptive stats and we did comparative performance analysis between benches and officers. We did purposive sampling for qualitative data collection. So how we created a list of lawyers, we looked at all the advanced rulings. It mentioned the name of the lawyers, and we made a list of the lawyers, and we found out their contact details online and through other sources, and we wrote to them. We reached out to them. Apart from this list, we also reached out to other lawyers who we thought would have done some work on advanced rulings, or they might have appeared before CAAR. Apart from that, we reached out to consultants and also CAAR presiding officers and a retired chairperson of CBIC for their interviews. Interviews were semi-structured, so it allowed flexibility and depth in discussion, but we had some areas of interest in mind, and we asked questions pertaining to those areas. The duration of the interview was 30 to 40 minutes. We conducted all interviews via Google Meet. We assured the interviewees of confidentiality, anonymity, and we obtained their informed consent, prior consent before the interview. The themes of our questionnaire, the kind of questions we asked, they were about, why do you file an application for an advanced ruling? How has been your experience with CAAR? And about the compliance with statutory timelines, factors contributing to delays, about quality and consistency of ruling, about appeals, scope of binding value, and if they have any suggestions and reforms. After we interview them, we record the interviews, then we transcribe it, and we clean, anonymize it, and then we did manual annotations. We identify and categorize the excerpts into key theme areas, color-coded them, and then we group them into broader analytical categories. And that's how we analyzed those transcripts. We also cross-validated our findings with LLMs using LLMs. For comparative purposes, we looked at United States, Canada, and Australia. Why did we select these three countries and not others? Is because there wasn't much information available on other countries, and we found one USAID report which already had some insights on these three countries. So that was our main source for comparison. We compared these countries on institutional structure, timeliness, binding nature and validity, and technical support. For institutional analysis, we compared CAAR statutory framework, de jure versus de facto comparison we did. So we looked at the actual procedural practices, which we found through interviews. And basically, we try to highlight gaps between the intent and implementation. Okay, now coming to findings. So as I mentioned, our first question was about the motivation. Why do importers, why do business entities seek an advance ruling? So it provides them legal certainty and it helps to mitigate any risks. It also helps them avoid costs associated with non-compliance, because if there are any classification issues that arise at the port, then it would lead to delay, it would lead to additional costs that nobody wants to pay for. It would simplify their operational decisions, because if they know in advance that this is the time that would take to import something, including the time at the port, then it just makes things easier for the businesses. So it streamlines their decision making as far as pricing is concerned, taxation is concerned, their inventories are concerned. When there's a new technology, for example, we saw a lot of cases. If you remember, there was an Amazon Fire Stick. It was new technology. And so for the purpose of classification, importers need to know what exactly this product category is. So if they import something and they think it's a TV remote control, but the port authorities think that it's actually an entertainment device and the classification differs for both of them, then they would be in problem, right? So to avoid such problems, what they do is they would prefer filing an advance ruling so that they can know exactly how would the custom department treat this object. And accordingly, they can figure out the classification. And if they don't file it, the custom department, the field officer may have a pro-revenue bias. So they would favor a classification which attracts a higher tariff. And advanced ruling, because that doesn't involve field officers. I mean, it involves field officers because it seeks a comment, but the decision is not made by the field officer, and hence it would be more unbiased. So based on the interviews, we found that stakeholders have a positive impression of CAAR. When we started the research, we were wondering, and theoretically speaking, that you have a system which is judicial, which is headed by a retired Supreme Court judge, and then from there it goes to quasi-judicial, wherein you have some commissioners who would then be acting as presiding officers. So maybe it would lead to bias. Maybe it would lead to more red tape. Maybe it might create, more problems. But the results were to the contrary. They're very counterintuitive, because what we got to know that the rulings were seen as clearer, more structured, and less revenue biased compared to previous CAAR rulings. And there was notable improvement because now it was not taking years to pass the rulings. It was only taking some months. So the target was 90 days. And I'll come to that. Maybe it was not 90 days that they were able to pass the rulings in, but it wasn't as bad as years. So it significantly improved the institution. So here are what some of the stakeholders say, that it took years to get a ruling. Companies stopped applying altogether. Now rulings come much faster, though delays remain. Having senior custom official instead of retired judges has reduced formalities and made the process simpler and more accessible. CAAR rulings are fair and transparent, providing structured reasoning. Filing for advanced ruling is simple, does not require extensive follow-up, making it an attractive option. More than 80% of the rulings concern classification. So most of the rulings are about classification, and more than 2/3 of the rulings were concordant with applicant position. So, which shows there is a lot of certainty in law. It aligns with stakeholder expectation or the interpretation of the law. Now, coming to the issue of adherence to 90 days limit for issuing rulings, and if there are delays, then what those delays are for, what are the reasons for those delays? So let's take a look at this table. If you see, this is comparison of 5 presiding officers, and we've divided the time into 3 categories. Law says 0 to 90 days. But to get a sense of, if it's 3 months, then if not in 3 months, then how much time it takes. So we created another category from our own side, which is 3 to 6 months. So 91 to 180 days. Okay. And interestingly, if you see Officer 1 is able to pass only 2%, which is only 1 ruling in 3 months. But on the other hand, we have Officer 4, who is able to pass 31 rulings, 86% of the rulings within 90 days. So there is a huge disparity, in officers' performance. Yeah. Now, if we further look at beyond 6 months, then there are 32%, there are more than 20% rulings that are being passed beyond 180 days. So what is the reason? The main reason we figure out is late submission of comments by port commissioners. Commissioners, if you remember, I just mentioned, they have 2 weeks to respond, to submit comments, but they often submit comments in 4 to 5 weeks, significantly impacting the 90-day time. And the presiding officer has an option to pass ex parte ruling. Okay. But do they pass ex parte ruling? Because what they do is the presiding officers on their own, proactively, they immediately forward the applications to commissioners. They send reminders after 7 days. They follow up in the 3rd week if there is no response received. They also ask their staff to make personal phone calls to port commissioners. Then they escalate via demi-official letters to commissioners. So they send DO letters. And one officer, mentioned that a demi-official letter goes to the commissioner by name. We chase it like anything so that we get the comments, because normally it is the time which is the cause of delay. Next slide. Slide 29. 29. So if they don't get the comments within time, then they will have to delay if they don't choose to pass ex parte. So that probably is the cause why different officers have different timelines. So maybe some officers, they are going ahead with ex parte, and some officers are choosing to wait for the comments received. And we looked at the data. So we didn't have the data for exactly when the comments are filed, but we have the data whether comments are filed or not filed, because that's mentioned in the ruling. But when the comments are filed, that's not mentioned. So there were two ways to, get more clarity on this. One was from the interviews, and in interviews, almost all stakeholders mentioned that the comments are not received in time and that the comments are worthless. The comments didn't really have any substantive inputs. It's cryptic, and they don't give much reasons or much details on why they think so. And usually the comments are not received in time, despite chasing so much. So, but why are officers reluctant to issue ex parte rulings? So one is that they want to avoid legal challenges, and one of them mentioned that this is a hearing, and so we also ought to give hearing to the department, to the port commissioners. If we don't give them hearing, then their right to be heard is lost, and we don't want to violate that right. We don't want appeals, but that is not correct because it's the departmental hearing. It's a quasi-judicial hearing, and so the department is making, the assessment, and so I don't think so that they ought to hear the department. They ought to hear the applicant because the department is making that decision. Number two is they acknowledge administrative constraints of port commissioners because they think that they may be busy or they may be occupied with other tasks. And so they are sympathetic and they don't want to go ahead with ex parte rulings. And third is they may have concerns about implementation resistance and force. So if the port commissioner's comments are not taken into account, then what if the port commissioner refuses to order an advance ruling? Which sounds very odd because advance ruling by definition are binding. Right. So what does it mean that if they don't honor it? It means that they may resist. They can't refuse to honor it, but they may resist. And if they may resist, then of course, the applicant will have to approach the higher authorities. The higher authorities will obviously instruct the officers, and officers will then let it go. But the delay cost would be great inconvenience to importers. And it has happened in one of the cases, Nina Opal case, where on some frivolous ground, that the commodity had some kernel husks, and so they insisted that it should be tested by FSSAI. The applicant got it tested by FSSAI, and then again they insisted that another authority should test it. And meanwhile, for 5 months, the consignment, the commodity, the goods were lying at the port. So it caused immense inconvenience to the importer. The importer had to actually approach the High Court, which the court then criticized, the field officers for harassing the applicant. So this is what can happen. So when we look at the comments, next slide, please. Then we see that one of the officers passed, who chose to receive with comments. So 24 rulings passed, but all with comments. So that means that they chose to wait for comments. They passed most of these rulings after 6 months. And the officer who passed within 90 days, most of their rulings were within 90 days, but without comments. So they passed ex parte rulings. Okay. There are other factors as well that came out in the interviews. So some people said that some cases are really complex, and so they need additional hearings and expert opinions. In some cases, it could also be because of the applicant. The applicant, may file a rebuttal late or may have a rescheduling request. CAAR officers do not have any research assistance. We also have limited institutional support, so they don't really have a lot of resources at their disposal. The online filing system is not there. It's basically submission through email. And sometimes the presiding officers are transferred. And so whatever cases they have heard, they will have to be reheard when there is a new officer. Now, internationally, if we see that these three countries, US, Canada, Australia, they don't rely on port officers. As I said, they don't have this adversarial system. Instead, they have in-house independent research assistants. They have specialized officers, which we don't have. Next. interesting is we may think that 90 days is, that it's a great achievement that we have at least almost half of the rulings getting passed in 90 days. So 46% of the rulings are, passed within 90 days. So this is great. But even 90 days may be too long for advanced rulings. Why? We interviewed one importer who had to import a specialized industrial computer part, which was, which basically made this entire operational run, right? And this part was worth rupees 50 lakhs. So he could not maintain an inventory of this part in case if something goes wrong. So when he had to import, the 90-day timeline was just too long, and he mentioned to us that there is no emergency provision or tatkal provision under which this whole route can be shortened. There is no alternative way to get the advanced ruling fast, right? So in such a case, waiting for 90 days can cause substantial financial and operational losses. Now coming to binding nature of advanced rulings. I will try and wrap this up fast. Two issues: port-specific applicability and limited temporal validity. So, one of the interviewees mentioned that my classification, product classification, why should it fall under X at one port and Y under different port? That should not happen, right? So this is barrier to inconsistency, and there can be varied interpretations by different port authorities. So stakeholders emphasize that there should be a uniform binding effect across all custom jurisdictions. And this is the case indeed in other jurisdictions in other countries, US, Canada, Australia. Rulings are considered to be binding across all custom jurisdiction, across all ports. Now, as far as time is concerned, Australia has 5-year validity, India has 3-year validity, and US and Canada have indefinite validity. So unless there is a change in the product or technology or law, ideally this advanced ruling should remain valid, because then the business entity doesn't have to file for its renewal or a fresh, it doesn't need to seek a fresh ruling. Okay, now coming to workload distribution. Do we need additional benches? So if we look at Mumbai dealt with 256 rulings and Delhi dealt with 158 rulings. So Mumbai indeed handles significantly higher workload. If we look at the state-wise contribution to the number of matters handled, Maharashtra alone has 95 rulings. It's responsible for 95 rulings, so 37%. Tamil Nadu, 31 rulings, so 12% of Mumbai workload, and Karnataka, 10%. So these three states account for almost 60% of Mumbai's workload. Now the challenge is 75 orders did not have company addresses, so we could not ascertain the source of those advanced rulings, which states are contributing. For Delhi, Delhi also has 34% caseload, but the absolute numbers are much lower than Bombay. Haryana, 14%, and UP, 5%. Again, for Delhi, the number of inaccessible rulings is even higher. So we didn't have data for 95, and therefore we couldn't do a comprehensive comparison of applicant states. Recommendations. So first recommendation is that instead of an additional bench, there should be dedicated research support for each CAAR bench. There should be assigned one classification specialist and one valuation analyst. And so this technical unit model, this technical unit then can provide structured technical reports within 7 days. It would minimize their reliance on board commissioners' inputs. And before rolling it out full scale, there could be a pilot implementation at one bench before full scale deployment. one interviewee shared that, the presiding officers would do whatever they could do before the hearing. So, for example, they could prepare the case structure, the case brief. They could, sum up the issue at hand. They could sum up the applicant's position because they're only waiting for the board commissioner's comments. So, meanwhile, they could do all of that. And then once they get the comments and once the hearing takes place, then they can, apply their mind and then give pass a decision. But until then, they could do all of that work in advance. So, for example, if it is 4 pages, then out of 4 pages, 3.5 pages is actually about the problem at hand, the issue, and the facts, etc., and the applicant's position. So all that can be done in advance. And so we propose this part at least can be done very smoothly with the help of AI or a large language model. Further, CAAR can also get a customized large language model for centralizing resources. So language model that understands or that has a database of classification, precedents, notification, trade agreements. US has its own database of precedents. And so, in future, this sort of repository can assist and provide support to presiding officers. The other 2 recommendations with regard to the applicability are kind of very straightforward, that we should amend the relevant legal provision of the Customs Act to mandate nationwide enforcement of CAAR ruling. We should eliminate port-specific limitation and ensure consistent enforcement across all custom jurisdictions. And for temporal validity also, we should implement auto-renewal mechanism for rulings. While working on, this project, we realized that many of the advanced rulings do not mention the date when comments were received. Actually, none of the advanced rulings mention. And some of the advanced rulings, as I shared earlier, that it did not have dates, etc. So many of the, case details were missing. So our recommendation is that even if the advanced ruling is a confidential one, at least non-sensitive case details must be disclosed for all advanced rulings. And this includes presiding officer, ruling dates, jurisdiction, subject matter, date of comments, additional information, rebuttals received, etc. And so advanced ruling must have procedural details, for example, number of days taken by board commissioners to submit comments, number of extension granted, and accurate specification of subject matter and applicant's address. That was another red flag, that most of the advanced rulings did not accurately describe the subject matter of the advanced ruling. We recommend that there should be a performance evaluation mechanism. At least they should maintain a data dashboard, which would have officer-wise case disposal rates, percentage of rulings issued within 90-day period for each officer, appeal rate, and some sort of ruling consistency metrics. Because, for example, there may be more than a dozen of advanced rulings on legal net classification. Okay? If it's the same product, there should be some consistency among those rulings. So are they maintaining that consistency or not? And then this data should be publicly accessible. Thank you so much.